Ooh, is Trump in trouble or not? Is that a yes or no question? What can the president do? And understand that the federal is sovereign, the state is sovereign, and the tribe is sovereign. Always remember that when you're dealing with politics. So let me go and dive in. So the question is, yes, to answer, yes, the United States president can deploy National Guard, but whether it's impedes on California sovereignty laws is complex. Legal questions that has been the subject of recent court battles. I'm going to tell you a breakdown. President authority to deploy the National Guard, Federalization, Title 10. The president can call the National Guard into federal service known as federalizing them under the Title 10 of the U.S. Code. This shifts their command and control from the state governor to the president. Circumstances of federalization, Title 10 outlines specific circumstances for this, typically when the United States is invaded or in danger of invasion. There is a rebellion or a danger of a rebellion against the authority of the United States government. The president is unable to execute the law of the United States with regular forces. The Insurrection Act, this is a separate but related set of laws that allows the president to deploy military personnel on U.S. soil without state consent in certain situations, primarily to suppress civil disorder or rebellion, or to enforce federal laws when they are being obstructed. The impact of California sovereignty in recent conflicts. The question of whether a presidential deployment impedes on state sovereignty, like California, is where legal challenges arise. Governor's role. Normally, the National Guard is under the command of the state governor. When the president federalizes them, it bypasses the governor authority. It surpasses the governor authority. Recent California lawsuit, California governor is under the command of the state governor. When the president federalized them, it bypassed the governor authority. Recent California lawsuits, California Governor Gavin Newsom recently sued the federal government over a presidential deployment of the California National Guard to Los Angeles, arguing it was illegal to take over in a serious breach of state. Let me break down California sovereignty a little bit, summarize it all in a nutshell. California sovereign law generally refers to California powers as a state within the United States federal system, the United States federal system, meaning its ability to govern itself on matters not reserved for the federal government. This is rooted in the California Constitution in the concept of plenary powers, allowing it to legislate broadly. California also has strong traditions of direct democracy. And we'll talk about plenary powers later on, enabling citizens to directly shape laws. It's important to distinguish this from two other very different concepts. Sovereign citizens movement. This is a pseudo-legal belief system where individuals falsely claim they are exempt from most U.S. laws, often leading to illegal activities like tax evasion. California independence movement. First, these are political efforts like Cal-Exit that propose California becoming an independent nation. However, the United States Constitution does allow states to secede without an amendment or a revolution. In short, California sovereignty law primarily means the legal authority California holds as a state, not a claim to operate outside the United States law or to secede sovereignty. Argument in the court. California argued that the president's actions exceeded his statutory authority and violated the 10th Amendment, which defines the power balance between federal and state governments. They also argued that the specific circumstance protest did not meet the legal threshold for rebellion. That would justify federalization. They maintained that federal law requires governor's consent for such deployment for domestic law enforcement. Now, the federal government argument. The federal government argued the president has the authority to federalize the National Guards to protect federal personnel and property, and enforce federal laws, particularly if there is a rebellion or inability to execute laws. They also argued that the president orders are to be issued through the governor, but this doesn't grant the governor a veto. Court ruling. Recent example. In a recent case, a federal judge initially ruled in favor of California, saying that the deployment was illegal and violated the 10th Amendment. However, an appeal court temporarily blocked this ruling, allowing the federal deployment to continue. With the appeal is considered. This indicates that the legal complexities and ongoing debate surrounding the extent of presidential powers in this area. In essence, while the president can deploy the National Guard, the legal debates and impacts on state sovereignty are often contentious, especially when a state governor opposes the deployment. These situations frequently lead to legal challenges that seek to clarify the precise boundaries of federal and state authority. Where California fit in with the plenary powers? This is in their belief system. Plenary power means full, complete, and unrestricted authority within a specific legal domain in the United States. States generally have plenary powers. They can legislate on almost anything unless specifically forbidden by the United States or their state constitution, or by valid federal law. The federal government has enumerated powers. It can only act where the United States Constitution specifically grants it authority. However, certain federal powers or the president's pardon powers are considered plenary within their specific scope. In short, it's the difference between being able to do anything not forbidden plenary versus only being able to do what's specifically allowed enumerated.